Welcome, everybody. All right, so it's 5 o'clock, so I will go ahead and get started. All right, so welcome to Family Law Now After Hours. Today's topic is parenting time and decision-making responsibilities. When parents separate, decisions about where children live and who makes major life choices become central. Parenting time and decision-making responsibilities, formerly known as custody and access, shape children's daily routines and long-term well-being. In Ontario, the court prioritizes the child's best interests, but many families can create collaborative parenting plans outside of court. So, just some housekeeping rules. Please use the question and answer feature to submit your general comments and questions about this topic. For specific questions about the details of your family law matter, please contact our team directly. The purpose of this series is to discuss general information on separation, divorce, and family law matters. Any information provided here should not be construed as legal advice. Please stay tuned until the end, as we will be sharing how you can schedule a free initial consultation with one of our lawyers. And to introduce our team here today, my name is Geneva Spencer, and I earned my Juris Doctor degree from the University of Windsor, where I developed a strong passion for family law, mediation, and litigation. As a three-time winner of the Windsor Law Mediation Competition, I am committed to helping families resolve disputes through empathy and collaboration. I gained valuable experience working at a non-for-profit legal clinic, supporting vulnerable populations and deepening my client-centered approach. Outside of law, I am also an avid equestrian and a dedicated volunteer with Girl Guides of Canada. I'm excited to be articling with Russell Alexander, and I look forward to applying my skills to support clients through their legal challenges. Joining me today is also Lisa Clark, a senior law clerk with over 16 years of experience in family law and who joined Russell Alexander Collaborative Family Lawyers in June of 2025. Lisa graduated from the law clerk program at Fleming College in 2009 and has developed a well-rounded understanding of the complexities of family law breakdown. She's a member in good standing with the Institute of Law Clerks of Ontario and recently received her designation as an ILCO certified expert in family law. Raised in Kawartha Lakes and now settled in Peterborough, Lisa enjoys photography, reading, online gaming, and spending time with her cats. Also joining us is Darla Weir, our managing law clerk, who brings extensive experience in family law and a client-focused approach. She prepares court pleadings, financial statements, and support calculations, keeping clients informed and supported throughout their cases. Recognized as a family law expert, Darla retired from teaching at Durham College in 2021. In her free time, she enjoys her family, traveling, and participating in charitable fundraising. So to start us off today is Lisa, who will be speaking to the definition of parenting time and decision-making responsibilities. Lisa?
Yeah, absolutely. So the defining parenting time decision-making responsibility. So most people are probably familiar with the term custody, which is not used anymore. Instead, we call it decision-making responsibility. And that just refers to the authority to make major decisions about a child's upbringing, including healthcare, education, religious or spiritual upbringing, extracurricular activities, those sort of things. And then parenting time refers to the time that the child is spending in the care of a parent or another person, such as a grandparent. So these include both in-person parenting time, could include virtual contact, the day-to-day care and supervision of the child. Um, and parenting schedules, which I know we will touch on later, can vary greatly depending on each party and each family. Um, the decision making ideas can be structured in a lot of different ways. So there can be sole decision making responsibility, which is where just one parent makes all of the major decisions. There's joint decision making responsibility, where the parents are sharing the decision making and they must consult one another prior to making a decision. And then there could be divided or parallel decision making where one party could be responsible for, say, the child's education and religion, and the other party could be responsible for the healthcare and extracurricular activities.
Great, thank you so much, Lisa. And then just to provide some guidance on the legal principles that guide parenting arrangements, I will speak to that. So parenting arrangements will include things like decision-making responsibilities, parenting time, and these decisions should be guided by the best interests of the child. So this is a leading standard for most, if not all, decisions surrounding a child. I won't get into it too much because Darla will be speaking to it later, but just as sort of like a broad overview of what are the legal principles. So I like to think of it as like there's the primary considerations and the secondary considerations. So the primary considerations are developing arrangements that make your child feel safe, supported, and loved. The courts will look to see that the child is going to be healthy and safe, and that's prioritized in the decisions. And then the secondary considerations, courts are going to consider things like the child's age, the presence of siblings, what has been the status quo, and fostering relationships with the parents. So I sort of consider those to be secondary because it'll always go back to the primary considerations of what is the best interest of the child. So of course, every child should have a relationship with their child, but sometimes there's going to be, circumstances where maybe that's not the best thing right now. So that's why I would consider like, like the relationship with the parent to be like more secondary. Because again, what's going to be in the child's best interest, what's going to be making them feel safe, supported, and what's going to contribute to their overall success and well-being. So there is no one size fits all. What is right for your child will be very different from, maybe the child that lives next door. So your agreements, and what guides your decisions, that can be informal, like be part of a separation agreement, or it can be ordered by the court. Regardless of how these decisions come around, it should be developed with the child's best interest at the center of those decisions. So a child can have a say in what they want. It's not always determinative, but it will carry weight in helping a court guide those decisions as to which parent should have decision-making responsibility and parenting time. The older child is, the more weight that their wants and wishes will have. And then when family law gets difficult, there are agencies that a court can and will bring in to ensure that the right decisions are being made for the child and to ensure that their interests are being protected. So that could be CAS or OCL. But typically, if there's two parents and they're able to communicate openly and honestly with each other and the child, that's typically not necessary. The court is more than fine to just hear what the parents have put forward, what their proposal is, and if it, lines up with what's in the best interest of the child, then there should be no reason why a court won't grant that. And now to speak to the types of parenting plans and schedules, Lisa.
Yes. So as I touched on before, there's a ton of different types of parenting schedules. First of all, though, a parenting plan overview is that is the written document that's just going to set out how the parents are plan on caring for and making decisions about the child after separation. So generally, it's going to include your parenting time schedule, the decision-making responsibilities, any communication methods, whether it's strictly to be in writing or via like a communication app. It's also going to include holiday vacation arrangements, transportation and exchanges, if applicable, and any conflict resolution process. And the great thing about all parenting plans is that they can be customized to fit every family's needs. So the common types of parenting schedules in a shared parenting, which is generally between 40 to 60% of the time with each parent, you could have what we call a 2-2-3 schedule, where the child spends 2 days with one parent, 2 days with the other, and then 3 days with the first, and then that rotates. Another option is a 2-2-5-5 schedule, where each parent has 2 weekdays and then alternate weekends. So for example, Monday to Tuesday with parent A, Wednesday, Thursday with parent B, and then alternating the weekend, Friday to Sunday. And then there also could be a week on, week off schedule where the child or children are spending one entire week with one parent and then alternating to the other parent for the next week, and so on. The next type of parenting schedules comes into effect when one of the parties or parents has primary parenting, meaning that one parent has the majority of the parenting time with the child or children. And then the other parent will have regular parenting time with the child, either, every other weekend and one e evening or overnight midweek, 3 weekends per month, and shared holidays. There could also be gradual increase in schedules for younger children. So they could start off with, a slower every other weekend and then gradually move up as the child gets older. There's also the split or parallel parenting, which happens when there are multiple children, but they live with a different primary parent. I don't see that too often, but it does happen. Um, and then the last one would be what we call a nesting or bird's nest schedule, where the child will stay in the family home, and then the parents will rotate who is living in that home at the time looking after the child. That's generally when the parties have a matrimonial home. And then there are also specific holiday and vacation schedules. So you can set a specific schedule about what summer parenting time should look like, Christmas holiday, March break, and those kinds of like vacations. Also, any variations in decision making, whether it's joint decision making, sole decision making, or divided, like I talked on earlier.
Great. And then I'll speak a little bit to how decisions about children are divided. So, two parents, you can decide that however you want. I would be mindful of the realities of your daily life, plan for emergencies, try to imagine future things to plan around. So, for example, like what happens if one parent cannot be reached? If someone has a new partner, will that new partner be afforded any say over anything? You can always remake an agreement. Maybe consider revisiting these decisions as your child grows. The child's needs are going to grow as the child does as well. Some common things, most decisions are shared. Also common that one parent to take lead on one area, perhaps education, the other one has the say on religion. Something I have seen before is one parent has the say where the child is in their care with the stipulation that the other parent is informed. And then other times, sometimes the decision is joint in all aspects, but maybe one parent will have the final say ultimately. So ultimately, it just depends on what is right for you and your family. Um, you can have your child make decisions where appropriate. For example, when I was going to high school, it was my choice if I wanted to stay in the Catholic system or to switch to public. So if you have older children, for sure, it's certainly worthwhile to sit them down and have a conversation about what it is that they want to guide these decisions. And then again, just open lines of communication. How these decisions should be divided. Very important that there's an open dialogue among everybody so that everyone's on the same page about what to expect, what's going to be expected of them and going forward. And then now to speak to the best interest of the child, Darla is going to let us know.
Thanks, Jen. Hi, everyone. Best interest of the child is the legal standard used by family in family law to guide decisions about the child's well-being. It prioritizes the child's physical, emotional, and psychological safety and development over the parent's interest. So again, it's the key factors considered when determining the best interests of the child's would be health, age, relationship with each parent, and the need for stability and views depending on that maturity. So our key considerations, again, child's well-being. So the primary focus needs to be the child's physical, emotional, and psychological health and safety. Parental relationships, the quality of the child's relationship with each parent and their ability to meet the child's needs. Stability, the court looks for arrangements that provide a stable and consistent environment. So again, if they're reviewing parenting plans, they're going to look at, is that a stable parenting plan for the child? Is that in the best interests of the child and the child's development? Of course, the child's views are a factor. The child's wishes and opinions are considered depending on the age of the child and maturity. Safety is also a factor. Is there a history of abuse, neglect, or family violence? This is taken very seriously by the court. Other factors, the child's cultural, spiritual background, as well as their relationship with siblings and extended family will also be considered. In my experience, it's very unlikely that siblings are separated. Usually the court will take the view that those siblings should remain together when they're determining that parenting plan. So how are those considerations and factors used? The principles are applied or should be applied by the parents, guardians, the courts, mediators, and any other decision makers who are making the decision for that child or that will be affecting that child. It is used to make decisions on matters such as parenting time, decision making. And again, as Lisa explained before, we used to say custody and access, but now we say decision making instead of custody and parenting time instead of access. So the factors are all considered looking at, again, what's best for the child. And the ultimate goal is to ensure that decisions are child-centered and serve to maximize what's in the child's benefit and minimize harm to the child. So thanks, Jen.
Of course. Thank you so much, Darla. Now, Lisa, could you please speak to the handling of disagreements and modifications?
Yes, of course. And it's a good, very practical question because especially depending on how old your children are, it is very likely that there could be some disputes as the children get older and the parenting plan will likely need modification. So for the most part, whether your parenting plan is incorporated into like a separation agreement or a court order, there's generally going to be a dispute resolution clause in there. So that is what you are going to start with because that will set out how the parents are to deal with any disagreements before returning the matter to court if it was in court. So common approaches for this can include direct discussions between the parents if the parents are able to communicate, mediation with a neutral third party, a parenting coordinator who is a professional who helps interpret and enforce the existing plans. And then arbitration, which is a private decision maker, and they issue a binding ruling if agreed to in writing. Um, but if there is no specific terms, generally in the first instance, you are going to want to try to come to a resolution outside of court. When a disagreement does arise, need to remember to stay child focused. The discussion should be about what is in, as Darla touched on, the best needs of the children and like what their best interests are. You want to use neutral communication tools. So there are parenting apps like Our Family Wizard that you can use to communicate with the other parent, document discussions in the event that it does later go to court. Avoid any unilateral changes. Neither parent should alter the plan unilaterally without consulting the other parent. Um, Parents can also enter for mediation. The trained mediator will help both the parents try to reach a compromise. It is confidential and faster and less expensive than going to court. The parenting coordinator is again, as I said, the professional who can help implement or adjust just details if they need to be tweaked in a parenting plan, if it's just like exchange times or holiday logistics, something like that. But they cannot legally change decision-making authority unless that's agreed to by the parents in writing or ordered by the court. So, and if the circumstances have materially changed, either party can request a modification. A material change can mean different things. Generally, it'll involve one of the parents moving, so it's a relocation and they're not in the same jurisdiction that they were when the agreement was first reached. A change in the child's needs, either in health or schooling, or a change in the parent's ability to care for the child. Maybe now they've suddenly gotten a job that sees them not being home as often. But always try to negotiate or mediate first. And if not, and you have a court order and you need to make changes to the parenting plan, you would proceed with filing what's called a motion to change the original court order. And then the court will consider whether or not a material change has actually occurred, and if so, whether or not the requested change is in the child's best interests. And then, of course, you have to keep into consideration any emergency or safety concerns with a child, and maybe that's the reason they're wanting to change the parenting plan, because maybe they feel the other parent has become unsafe. But if that ever happens and you do have a child protection concern, you should be contacting your local authority for that. And if absolutely last resort necessary, urgent motions can be brought to the court, but the threshold for those are generally typically high. And there are like very specific steps that would need to be reviewed and consulted with your lawyer before deciding to take that step.
Great advice. Thank you so much, Lisa. Darla, could you please speak to the role of family courts and mediators?
Sure. So family courts and mediators and the differences. Family courts make final decisions on parenting issues if parents cannot agree. So that they always ensure it's in the best interests of the children, but it might not be the outcome that you necessarily are seeking. So as both Lisa and Jen have mentioned, it's more cost effective if instead of going to court, if you can utilize a mediator. Going to a mediator in family law is completely voluntary. They're a neutral third party that will help facilitate discussions with the parents to come up with solutions. Again, that's going to be in the best interest of the child. So that neutral facilitator or that mediator is that neutral third party, and they help parents discuss and resolve disagreements about parenting arrangements, such as parenting time or decision making. The mediator is typically a non-decision maker. So it doesn't make the decision for the parents. It encourages them to have open discussion and guide them through that discussion to come up with a final resolution. The parents can usually communicate directly and identify key issues and explore potential solutions to come to a final resolution. As Lisa mentioned, mediation is typically cheaper. It's usually faster because there's quite a backlog in the court. And it's usually less stressful as well. Like going to court can be very stressful. So if you're able to resolve issues with a mediator, it's really a win-win situation. Once you do have a final parenting agreement through the mediator, you can always submit it to the court and have that turned into a court order. Usually that is by way of what back in the day we were referred to as a basket motion. Lisa, I know you would hear, I don't know if you know that terminology, Jen, that's pretty old school, but it basically means you're filing the documents with the court and no one is required to attend in person. The judge is reviewing that agreement in chambers and then will grant the final order in that regard. Now, mediation isn't necessarily suitable for everyone. If there's been domestic violence, family violence, then mediation might not be an option for your family. However, mediators can also do a shuttle mediation where you're not both in the same room at the same time. So that's another option. And then the role of the family court, again, they're the final decision maker. So whatever decision the court makes is final and binding. So if you're able to come to that resolution through either minutes of settlement or mediation, then you're controlling the outcome. Once it goes to trial, you're not necessarily going to see the outcome that you hope for because there is no crystal ball or guarantees in family court. Trials are also very, very expensive. So again, this is an alternate resolution to deal with the issues. Now, the court will always review what's in the best interest of the child, as I discussed earlier, based on, excuse me, based on that child's age, maturity, the child's needs, and the parent's ability to meet those needs. The court will also enforce orders. So if there is an order that is not being complied with, then you can seek that the court enforce that final order. Or as Lisa mentioned, if there's circumstances that require that final order perhaps to be varied, then you can go to court and issue a motion to change to vary that final court order. Court is usually Hopefully a last resort for you in high conflict cases. So again, it's better to work through mediation or collaboratively to get to that final parenting agreement that's going to be best for your children and your family.
Great. And on
Thanks,
that
Jen.
note, Lisa, could you walk us through the impact of separation on children's routines?
Absolutely. It has a huge impact on the child's daily routines. It's mainly it's going to disrupt their daily stability. Kind of everything they know has changed, right? So their sleep routines are going to be different. Their eating habits are going to be different. Their homework and school routines are going to be different because maybe now they're going into after school care or have to be supervised by someone. Their extracurricular activities will likely change as well because there could be transportation or scheduling issues now. Children are generally going to do best when they have a predictability and consistency in their schedule. So it's really important to reestablish that stability and schedule as soon as possible post separation. They're also going to experience emotional and behavior reactions, which is completely understandable. They're likely going to experience sadness, anxiety, confusion. They are probably going to have loyalty conflicts and feeling like they're going to be torn between their parents and having to choose a side. There could be some regressive behaviors if the child's younger, they could start becoming more clingy, acting out, bedwetting even. Like it's really something you really have to pay really close attention to your child's behavior when separating, because they could also start having difficulty concentrating at school. It really is just affecting their their entire life. There are adjustments between households now. Now they have to go between two houses. So that can be challenging to get used to at first. They're likely going to need reminders of what to pack, where items are kept, what they're going to be able to expect each week at parents' homes. Each parent's homes, they could have inconsistent rules or discipline, and that could cause some confusion for the child. And over time, most children are going to adapt well as long as the parents can maintain their structure, predictability, again, and open communication. And then there are developmental considerations that are going to impact the child depending on what age and developmental stage they're at. So young children, age newborn to 5, they, thrive on routine and physical closeness. So frequent, more shorter parenting times can help maintain that attachment. Some more school age, you're getting kind of 6 to 12. They're starting to understand the separation, but they could be internalizing blame. So they, again, like as all the children will benefit from stability in their school and activities and schedules. Uh, Teenagers, they're going to value their self like more at that age. So they're probably going to prefer more flexible schedules, but they're still going to need that parental consistency and emotional support from their parents. So some factors that'll help the children adjust is more smoothly is when parents can cooperate and communicate respectively. That's really important. And to keep the schedules as consistent as possible and keep transitions predictable. Both homes should follow similar rules, routines, and expectations for the children. And the child should be feeling free to love both parents without feeling any guilt or like they need to choose sides. So any major changes should be introduced gradually and explained clearly so that the child has some understanding and can have that kind of confidence in it.
Great advice. Thank you so much, Lisa. Now, Darla, can you please speak to the communication tips for co-parents?
Sure. So effective co-parenting communication focuses on respect, directness, and keeping children out of conflict. That's really important. Actively listening, focusing on solutions rather than problems. Prioritize the children's needs and well-being above everything else. Maintain open and consistent communication and respect each other's time and roles. So, communication strategies, again, be respectful and professional. Treat your co parent as you would a colleague, using polite language and avoiding sarcasm, insults, or blaming each other. Keep it brief, informative, friendly, and firm. So stick to the facts, be concise, maintain a cordial tone, and be clear about what you need or what you are communicating. Listen actively. Like, again, I can't stress enough. Like, think about what's best for the children. You're co-parenting these children or child, and it's in their best interest that you're respectful to each other and can actively listen, provide your full attention, avoid interrupting, and try to understand their perspective. Stay focused on the children. So keep the conversations strictly regarding the children, their schedules, their health, their school, and avoid discussing personal conflict or bringing up past conflict. Communicate directly. Do not use the children as messengers. If you need to convey information, uh, speak to each other directly, or as Lisa discussed, there are parenting apps. Our Family Wizard is an app that you can use for communication. In addition, App Close is also a great app you can use for communication. Focus on solutions, not the problem or the conflict. Maintain boundaries. So don't micromanage each other as parents. Respect your different roles and your parenting styles as at their home and your home. Communicate in writing when possible, again, using your parenting app. Be flexible. Life changes. And be prepared to, be flexible with that schedule if necessary. For example, it might be the co-parent's birthday weekend, and be open to switching a weekend or switching a day, because that's for the benefit of the child. It's for the benefit of the parent, but really, that child wants to be able to spend time with both parents on their birthdays or family events. How to handle disagreements: acknowledge each other's feelings, and don't, be accusatory or use a language such as "you did this," things of that nature. Avoid blaming each other. Don't engage in unproductive communication. So don't be sarcastic. Don't insult each other. Again, don't point fingers at each other, and maintain boundaries and be respectful. How to not involve the children: don't disparage the other parent in the presence of the child. I know I'm going through all these things that seem very logical, but family law can be very emotional. And sometimes we forget that there's little ears in the room. And so just be mindful of that. Don't ask the children prying questions about the co-parent or their households. And support the relationship with both parents. It's important that children feel safe and secure, and that they can have the ability to have a relationship with both parents. Thanks, Jen.
Great information. Thank you so much, Darla. And now to navigate the difficulty of a separation and divorce, Lisa, can you please speak to the resources for parenting support?
Absolutely. So there are, if you've seen me in other events, you will know that I am going to tell you to go to Google because that is going to be like especially to find your more local resources that are specific to your area. Because like, for example, I'm located in Peterborough, and in Peterborough, we have the Peterborough Public Health has a lot of parenting resources. We also have a service called Canark, which has a ton of family services and like parenting courses and that type of thing. There are other resources that are out there as well. There's the Children's Mental Health Ontario Family Care Center, which offers, some evidence-based resources to help families. Um, there's parents resources on ontario.ca that you can find. There's more specific kind of mental health and specialized support that you can find in different areas too. So for example, Eastern Ontario has a program called Parents Lifeline of Eastern Ontario, or PLEO, and they are a nonprofit family peer support organization. So sorry, the parents of children up to age 25 are facing mental health challenges. There's also family and caregiver supports through a program called CHIO. There's peer support and community-based programs, which again is why I say Google is your friend. Just you want to see if what your local jurisdiction has to offer you. So there is one service throughout Ontario that's called Hope. It's helping our parents evolve, and they offer virtual support groups. So that would be better for someone who maybe cannot get out to do the physical courses in your area. And then there's also an association of parent support groups in Ontario. They have support groups that help parents develop more effective strategies, set limits, boundaries, and build kind of better relationships with their children. And then there is also what's called the Parent Support Network, which offers free workshops and resources for parents aiming to, encourage and educate and support the parents of kind of school-age children.
Great, thank you so much. Well, that concludes our information for our attendees here today. So we're going to go over now to our audience questions and we will answer them. So our first question, what about infants under the age of 1? Any specifics when it comes to parenting time? Does the child usually stay with the primary parent solely before they hit 2 if the parents don't get along?
Not necessarily, but again, talk to your lawyer.
I think usually it's funny because I had something come up today and I emailed Jen a question about that. But typically, if a child is an infant, a parenting time is usually shorter duration, and more frequent. Um, but again, like that, every situation may be unique and dealt with on its merits. But if it is an infant, usually it doesn't mean that the other parent is not going to have parenting time. Um, for example, if mom is breastfeeding, that doesn't mean that the other parent is not going to have parenting time, which sometimes people assume that. And it's usually shorter and more frequent parenting time visits.
Yeah, so you'd likely, like I touched on earlier, start with that kind of gradual increase schedule that you're going
Yes.
to start off with the shorter periods of time and eventually build up to the longer.
Great, thank you so much for answering, ladies. Our second and last question, what if parents agree on some schedule, but you, as a professional, are not sure if that's the best for the child, if you have some emotional safety concerns?
I'm sorry, I'm not sure I understand the question. The A professional has suggested or recommended a parenting plan, but you're not sure that that is going to work. Is that the question?
My interpretation is like, I guess us as professionals, if we see parents agree on a schedule, but I guess us as the professionals are not sure, on the basis of maybe like an emotional safety concern, like I guess what is our input? That's how I'm interpreting the question.
Mhm.
I think at that point we would probably seek like a third party, like parenting plan coordinator or something come in
Yes.
to help work with the parties at that point.
Mhm.
Yes,
And
and that makes
obviously, the child's age is going to be a factor, like age and the maturity of the child. That will be a determining factor as well.
Yes, and then a lawyer does have a duty of candor to their client. So if your lawyer is representing you and they do not think it's in the in the best interest of your child for whatever reason, they do have an obligation to tell you that. Now, as a client, you are welcome to disagree, but it is your lawyer's obligation to at least say that and have that heard. All right, we do have, oh, we've got more questions coming in. All right, we have another question. Is parallel parenting becoming more encouraged in mediating at a parental plan and or ordered in high conflict cases?
Yeah,
Hopefully.
the parallel parenting are generally only used in high conflict, where like the parents cannot communicate at all. Like it's really not a common type of parenting schedule that you see these days because most parents are going to try to work and communicate together so that they can have a parenting plan that is in their child's best interests.
Okay. Thank you so much. And our next question, how domestic violence from one parent to another parent is seen in family court? Is there any impact on parenting and decision-making responsibility granted to the violent parent? So let's just break this up. So for how domestic violence, how that is seen in family court, that absolutely is a factor, 100%. How a court will address that is very dependent on the case. Oftentimes it's going to result in supervised parenting time where the parent who has the parenting time has a third party to oversee. The second part of the question, is there any impact on parenting and decision making granted to the violent parent? Um, it depends. Darla, at least, did you guys want to comment?
I was just gonna, oh, go ahead, Darla.
I was just gonna, if the primary parent has sole decision making, then generally speaking, they're going to make all the decisions with respect to education, religion, or healthcare. But if it is joint, then the other party does have a say. That's basically the two differences. Um, do you want to add to that, Lisa?
Yeah, I was just going to say the court's really going to determine on a case by case basis because it depends
Mhm.
on the severity of the violence and who the violence was against. Was it against the parent or against the child or both? Like there's a lot of factors that need to be taken into consideration, but yes, the court does take domestic violence into consideration when coming to the decisions about parenting time and decision making.
Absolutely. And we can see that like the court is always going to try work with families. If they just can't, it really is a safety issue, then of course, that'll just, they'll work through that. But a court does want to try work through issues. So they will bring in CAS, which is Children's Aid Society, OCL, Office of the Children's Lawyer. There's all kinds of entities that courts will work with in cases where abuse is a concern and how that might impact the family or the child. It just depends. That's kind of one of the beauty of our court systems is because life is just so nuanced and everybody's family and what they're going through is so different because we have a court system that can respond to everybody's individual concerns and issues. It's just one of the many great things about having a court system like Canada's is that they're able to respond and sort of mobilize the individual needs of every child and every family. Okay, well, so with no further questions, I will wrap up. So thank you to everyone in attendance today for tuning into Family Law Now After Hours. After the session, a brief survey will appear, which will allow you to share your comments and suggestions for future topics that you would like us to explore. Your feedback is greatly appreciated. So please book now to take advantage of this opportunity for a complimentary consultation with one of our lawyers. Please contact our intake team at intake@russellalexander.com. Again, that is intake@russellalexander.com and mention our After Hours series to schedule your appointments. Registration is now open for our next event, which is A Parent's Guide to Child Support. So please go to www.russellalexander.com/family law now to sign up. Thank you to our amazing panelists for sharing their insights today. And thank you again to everyone tuning in today. Have a good night, and we will hopefully see you next time. Good night, everybody.
Bye,
Bye.
everyone. Thank you.